1 week? Or do you want to go forward?
Just go forward, Judge.
All right, are you Marissa Tibbitz? And Ms. Tibbitz is on probation for, in 2 cases, for aggravated robbery, second-degree felony. And, is that right? That shouldn't be right. Aggravated robbery would be was it pled down or something?
Aggravated robbery. Aggravated, yeah, that's what I thought.
Let me look back here real quick. I just want to make sure what my,
It was, the motions say aggravated robbery.
what does the original paperwork say?
Yes, they were aggravated robberies, Judge.
But they're second or first?
First.
Okay. Give me just a second to look back. I want to make sure. Yeah, the written plea admonishments back from the original plea is marked first-degree felony robbery, aggravated robbery. And that's what the commitment and everything was. So this is just a missed typo in the updated pre-sentence report. They're both first-degree felony offenses, placed on probation October 29th of 2018, was previously here, entered a plea of not true to a new offense of burglary of the habitation and a curfew violation, and then entered pleas of true to testing positive for methamphetamines and marijuana and being behind on our court-assessed fees. I've received the updated pre-sentence report. Has everyone had an opportunity to review that report?
Defense says.
Yes, we do.
And so the burglary of the habitation has been indicted, and so there's no evidence to put on today with regard to that offense, is that correct?
Just let the court know what's going on. I had sent out letters to officers and to the victim in the case. After a lengthy discussion on the phone with Bo Baden, the victim of that burglary, I determined that we weren't going to need officers because he was going to be able to prove up everything along with the history and the background of the two, because they were married at one point, had separated, and it was him. She had moved out, and it was his door that she came and kicked back in and destroyed a bunch of property. Although in the PSI, I believe she said it was mostly her property that was destroyed. That's not his version of it. We're not going to dismiss this at this point.
Okay, but you don't have evidence with regard to it today?
I don't have evidence with regard to it today.
So all I'm doing then is going forward with regard to positive test for methamphetamine and marijuana on March 18th and being behind on fees. Okay.
And the evidence that she does say she knows that she made a mistake and deeply regrets. I mean, her version of it recounts that an incident occurred on that night.
I don't think that's even enough for a finding of true, just unless she's going to plead true. Okay. So my inclination is this. I mean, we kind of cut to the chase here. Without that allegation at this time, I'm not inclined to revoke her probation. It looks like probably some type of drug treatment. She's even said she would want that and be amenable to that. And so if I'm going to continue her on probation, I think that's probably where we go. And then if the case moves forward, well, I can't send her anywhere with that case pending.
My thoughts, Your Honor, again, I sound like a broken record up here, but mental health, and there's through MHMR. There's a substance abuse through MHMR. Also, I think residential treatment through Franklin House, they can coordinate through MHMR as well.
If the court is inclined to send her to special needs safety,
I can't
She has a
with,
pending-
I would be willing to dismiss the burglary of habitation. We do have a non-prosecution affidavit from the complaining witness.
I mean, that's what my notes are, I'm inclined, I think, just based on the nature of these underlying offenses, then I would think the special needs safety gets us everywhere we need to be, potentially, especially if the other case is going to go away.
She said ISF.
No, if there's mental health issues, it's going to be special needs safety. I think that addresses both issues, and that's the only way I'm going to go along with any agreement like that.
And then the burglary to have is dismissed. If you want to do that. Otherwise,
I mean, I can do it anyway.
yeah, I understand, but the problem would be that him dismissing the.
Right.
burglary to have.
But if I'm going to do that, it sounds like you're probably satisfied anyway.
Okay, so
All right, so here's what I'm going to do. I'm going to find, Ms. Tibbitz, that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each of your cases to find you guilty and revoke your probations, but I'm not going to do that today. You are being given the opportunity. This is your second opportunity because your first one was, these were caps. When I first put you on probation back in 18, it was actually unagreed, and I took a chance and placed you on probation. It sounds like, and there are some things in this updated report that you've actually done very well while you're on probation. And so you need to make sure and get everything, any issues with regard to substance abuse, self-medicating because of any mental health issues. We're going to give you all the help you need to get the tools to be successful. And you'll go, I'm going to continue you again on both of these probations, order that you enter and successfully complete the special needs safety program. You'll do that, you'll get out, you'll have help, aftercare, and then you're still on these probations. If you do everything right, take advantage of it, you don't have the felony convictions, and you stay out of prison. If, however, you violate any condition of probation after today, I'm going to look back and wonder what I was thinking, because first I gave you an opportunity when it was a cap. Now I'm giving you an opportunity with some other issues and possible new case. So you're not going to get this opportunity. You will be on zero tolerance when you're back on probation. That means you have to do everything right. Do you understand? If you don't, you will be back in here, and you could be facing going to prison for anywhere between 5 years minimum up to the rest of your life in prison. Do you understand? Right.
and I think that the PSI noted that she was up to date on her fees.
Yeah, I mean, there's some good things in here, and we got to get the rest of this, the issues taken care of so that you won't make bad decisions and get yourself back in here like you did this time, okay? You can go back with the bailiff. And I'll sign the dismissal when it comes through. And that assault is from September 27th of 2024, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen? You're a U.S. citizen.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Stewart is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser included offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. It's coming. My computer's getting tired too. All right, good luck to you, sir. You can go back with the bailiff. For 23-1559, Give me just a second, please. All right, so on probation for the state jail felony offense of theft of a firearm, placed on probation March 11th of 2024. There's a second amended motion to revoke unadjudicated probation that's been filed with allegations from not reporting, not doing community service, using alcohol, arrested for assault in Harris County, failing to report for an administrative hearing, out past curfew. Another arrest for possession of a marijuana on June 18th of this 2025. Arrested for unlawful carrying a weapon, possession of marijuana, again, out past curfew. And so it looks like we already had in April a motion for me to set the bond, which I did. Set a bond in this case at $50,000 and required that there be a GPS, remain in Jefferson County, and no contact with the complaining witness in the Harris County assault. Typically, I don't entertain second motions for bond unless there's some new information or evidence. Ms. Holmes?
We was requested by the family to request a reduction. I believe his bond was raised at a time, I don't know if it was an initial or designation docket. I wasn't present when the bond was raised to $200,000, so I'm not sure of the circumstances surrounding it going up to $200,000. Based on my conversations with Mr. Zarate Jones, he was tested in court. He tested negative for any substances, but I believe it was because of the arrest in June that prompted the increase to $200,000. I did check with the district attorney's office. There has not been any cases received at this point from the district attorney's office, and we've also been in contact with Harris County. It's our understanding that that case in Harris County will be dismissed. That's my understanding. He does have an attorney in Harris County that is working on that. But I do believe that the $200,000 is maybe a bit.
Well, it's 50. I reduced it to 50.
No, right now it's $200,000.
That's my understanding as well.
Yeah.
So after I reduced it, no, hold on.
He
After April, I did something else. Is that what?
Yes, I believe because he was arrested for the possession.
Arrested again
Yes.
after I
Yes.
did that.
Yes, and I believe he was taken into custody when he came to court in June, I guess.
Yes.
Yes, I apologize, that's my fault.
The cases, though, have not been dismissed yet in Harris County. Is that
No,
correct?
the assault is still pending. Correct. That's
what
just
if-
what I've been told. And the case here, the possession and UCW has not been received at the district attorney's office. They haven't been sent over from the agency.
Have you checked on that? I know the marijuana, I understand if there's some lab issues, but with regard to the UCW,
I haven't checked on that, Judge.
okay, so here's what I'm going to do. I want to know the status of that. Obviously, that's what causes me the most concern, probably about, well, that and the assault, but the fact that I gave a probation, I gave a bond, and then there was an arrest for both of these things after that gives me, obviously, that's why the bond went up. I'm not going to reduce the bond today, but I am going to ask Mr. Coleman if you could please find out the status of that UCW, if it's going to be filed. If it's not, I'm going to reset this for 2 weeks. And the motion and the marijuana as well, but more so that UCW and what the status is and what the anticipated, if y'all are going to move forward on that, because that makes obviously the biggest difference for me.
Yes, sir.
And so what I'll do is I'm going to hold the motion. I'm not going to require you to file another one. I'm not going to deny it today. I'm just going to hold it for 2 weeks. I want more information on that UCW. And also, if you can find out anything you can from Harris County with regard to the status of that assault, if there's court dates, if there's dismissal or whatever,
I
then we'll
believe
see where we
they-
are.
When he went into custody, he missed that court date, so Harris County issued a warrant.
Right.
So I think there's no court date pending at this
Just
point. because
until they
it's a
get them.
warrant.
Okay.
Yes.
But maybe you can just see what the status of that assault is. Okay? We'll see you back in 2 weeks.
Okay.
Thank you.
With that, the judge puts the bond reduction request on hold and makes it clear that more answers are needed before any decision can be made. The pending weapon charge and unresolved assault case remain major concerns, and those details could completely change the outcome. For now, the defendant will have to wait another 2 weeks as the court gathers more information. But what do you think? Was the judge right to be cautious, or should the bond have been reduced today? Let me know in the comments.